Hello, and thank you for joining us for our COVID-19 Business Impact webinar. I'm Whitney Roseborough, one of the marketing coordinators here at Squire. We are excited to have you joining us today. Before we begin, I want to point out a couple things to you. We have a Q&A section where you can ask any questions throughout the presentation, and at the very end, our presenters will address those. And also in the Q&A section, I have included a couple of links to some Squire business resources. We are here to help, and we know there are a lot of opportunities available to you. Now let me introduce you to our awesome presenters today. First, you will be hearing from Tawny Rodriguez. Tawny is the Human Resource Director for Squire. She has been in HR for 9 years and enjoys and loves what she does. She specializes in many different areas, including benefits, training, onboarding, recruiting, and compensation. And then wrapping up today's presentation will be Tim Larsen. Tim is a CPA and advisory partner here at Squire with over 40 years of experience in public accounting. Tim provides expert business operation and management consulting. So without further ado, take it away, Tawny.
Great, thank you, Whitney. We appreciate it. We're so excited to get this presentation out there for people. I know we get quite a few questions on both of these topics. So let's get started on talking about furloughed employees. So there's quite a few people out there that businesses that may have had to furlough or terminate their employees or do other types of things. And so you will soon possibly need to make some decisions on what to do with those employees who are currently on furlough. So there's a few questions. Will you bring them back or will you terminate them? And so there are a few things when bringing them back that you'll want to consider. So you need to consider that employees, they may not want to come back. They may have found employment elsewhere, or they may have not felt great about being one of them that was selected for the furlough or the termination. So you do want to give them some time to decide if they do want to come back. So one recommendation is to have give them create an offer letter, because employees are going to have lots of questions. And so give them the option to accept or decline your offer. You also may bring them back with different options than what they had before. So people are going to be interested in finding out what benefits, what position they're going to be brought back to, if their compensation stays the same as what they were before. So sending out an offer letter would be a great option to just clarify some things with employees. Another thing that would be awesome is just communicate new safety rules that have been implemented since they've been gone. And so that would be something important. Either you could include in the offer letter or just communicate that information to them if you decide to bring them back. If you decide that you need to separate permanently, you can just notify them that after further evaluation that you won't be bringing them back, and you can terminate them in the system. Let's move on to this. So there is risk in determining who. So I'm sure at the time that you decided to furlough or terminate employees, it was difficult to decide who. And so one thing I would tell you is to be cautious when you're deciding who to bring back as well. So ideally, an employer would bring back everyone who they furloughed, but because of the situation and the current mandates, every business may not need all the employees back for operating purposes. So I just want to say be cautious how you select those and keep those who do not with risk of potential discrimination claims. So either consider, so first of all, do consider documenting the reasons that you are going to bring them back, how you select who you're going to rehire. If you see in the middle of the screen, it says reasons for selection. So these are some of the ways you could determine. So you could do it by seniority. You could do it by the current need for the position, or if there's documented performance issues, then you could bring them back that way. But one of maybe think about what was the reason for selecting those who you terminated or furloughed in the first place, and then possibly bring them back. So if you did it by seniority, it's safe to use the same reason when rehiring. So you could bring back those who had more seniority at the time. So that would be, you know, kind of a safe way to do it, but kind of determine what's best for your company, and be cautious. So I know this could happen, and so that's why I mentioned this. Be cautious that you don't make decisions based on the employee's risk level to COVID-19. So there is such thing as discrimination on age and pregnancy. So be cautious that you don't not bring somebody back because they are at higher risk for contracting COVID. So now let's talk a little bit about new hire paperwork. So you'll want to provide rehires with any documents you would a new hire. And some of these documents are included, like your W-4, your direct deposit, if anything's changed, I-9, have the employee sign the handbook, so a new signature accepting the terms. And as a rule of thumb, if it's been more than 6 months, then new paperwork should be filled out upon returning. But if it's been less than it's upon hire, then an employer can choose to have new paperwork at any time. So if you want to be safe, then you could do it even if it's less than 6 months. Okay, we're going to talk more about the rehire paperwork. So if an employee's been gone for a little while, then you can do a background check after a furlough, but you need to just make sure that you get the appropriate consent before running the check. For some consent forms, you may use from their first initial hire that they filled out if it has an evergreen language saying, but states like California, they require a new consent form with each authorization. So you'll either want to check with your state laws on receiving consent or just receive a new consent if you're going to do your background check. I-9 checks, so there's some new, at least there's one new thing when it comes to the I-9 checks. And so there's temporary guidance for remote I-9 document inspection. And so those of you who are familiar with I-9s, in the past and permanently we're not allowed to receive documentation remotely. You have to see it in person, but they have made an adjustment temporarily for those who only applies to employers and workplaces that are opening or operating remotely as a result of COVID-19. And so if your employees are physically present at the work location, then there's no exceptions being implemented. So you can only do it if they're going to be remote and not be physically on site. Other than that, there's a few things you probably need to know about I-9s when you have a rehire. If the employee was handled as someone on leave in the system, then you can keep the original I-9 document. But if moved to termination status, then you will need a re-verification or a new I-9 is required. So if it's terminated in the system and it's been more than 3 years since they filled out the form, so you have to check on their hire date there, then you would need to fill out a new I-9 form. And just a reminder to everyone, starting May 1st, you're required to use the new form. That's the version 102119, and it has an expiration date 10/31/2022. So keep that in mind. The past I-9 hasn't changed. If it hasn't changed from the previous, so if you pull out their I-9 form, you can just fill out the rehire date in section 3 and sign and date the form. So you wouldn't have to have them fill out the whole thing. Or if the past I-9 authorization has expired, then you would want to re-verify employment in section 3 and provide the rehire date. And if it's not a current version, then pull up the new version and just fill that out and attach it, the section 3, and attach it to the old version. And then Section 3, if it's a past I-9 and it's Section 3 is filled out already, you can also attach a completed Section 3 on a new I-9 form and attach that. So there's, depending on what the I-9 looks like for that rehire, there's certain guidelines for that. So I think this slide will be helpful in the processing of that. I know we went through some hiccups with trying to figure out if we could do some for remote workers, if we could look at their documentation remotely, or if we had to have them actually physically show it on site. So this was helpful for us to be able to see that. Now we're going to talk about that we're currently in Utah's moderate risk in the orange area risk phase. I know some of you may not be in Utah, and so other states may be in a different zone or phase. Orange and red, there's not a whole lot of differences there. So, but you should be able to see a plan to return for your state on their state website. You will also find different plans down to even the county sometimes, and each business is starting to create their own plans as we move to the next phases. So for most plans, there are not a lot of changes from red to orange, but you can read the information that what are the different items in each category. So as a business plans to reopen their doors or to invite workers or furloughed employees back into the office, they need to be prepared with questions that employees might have. Consider these following questions. So can my employer take my temperature and ask if I'm having symptoms? You're going to have that, you might possibly have that question. And so employers can ask for coronavirus symptoms and require that an employee takes their temperature before entering the building. But no matter where you put the station for taking the temperatures, you need to remember that employees need to be compensated for the time it takes them to do that. So either have some type of log or a computer system, or just have employees be able to be compensated for the time it takes them to take their temperature. Another question they'll have is, do I have to wear a mask to work? Most employers are adopting that every employee who is within 6 feet of another employee wear a mask, but check your state laws as to whether it is required or not. Utah has a program called A Mask for Every Utahn. So they provide a mask for those that don't already have one and can't make one or purchase one. So if people don't have that, then they can go to the website that I've also provided here. And maybe also have Whitney include that in our link so that people can easily get access to that. Next question is, what happens if I or my coworker gets sick with the coronavirus? So that question, if it hasn't already come up, you may see that a lot as you open the doors for people to come in. And so what we have done is created as part of our phase-in plan, a plan if someone gets sick with COVID so that they understand. So another thing you'd want to do is understand the FFCRA that includes paid sick leave and expanded FMLA, and track employees and clients who come in the building so that you can track if somebody may have come in contact with someone that has contracted COVID and go through that process. And then the last question, what if an employee fears coming in? So you may have already had this come up, but just be aware that people are scared, and just be flexible and patient as well as we all progress through this. The employees just want to know how you as the employer will keep them safe. Communicate clearly and often all the safety steps being taken, update any employee handbooks with created new policies that have responsibilities for the employee and the employer, spell out what approaches are being made to keep people 6 feet apart, and whether you have to wear a mask and those types of things. So one example of this could be we're going to prop open doors to eliminate touching door handles. And so that's just a simple one, or putting plexiglass in front of people who have more contact with others, or other types of things. So think about also maybe staggering shifts, and decide how and if you will allow in-person meetings or keep virtual meetings even at work. So those are a few of the different things that you can kind of consider as you have employees coming back in and they're nervous about coming into work. So many businesses may have already had to work with their employees as they've qualified for paid leave. So we've talking about the FFCRA. And so there have been a lot of questions on how to claim taxes and get reimbursed for it. And so I'm going to turn the time over to Tim so that he can talk about the process there. And we'll wait and do the questions at the end. So if you have questions for me as well, go ahead and stick those in. But we'll go ahead and turn the time over to Tim.
Thanks, Tawny. So I'm happy to be here with you today. It's not always a fun topic to talk about sick pay, but we'll do that in this presentation today. And I need to ask Whitney, can you see my screen? Tawny, can you see my screen?
I can still see my screen.
Okay, so something did not go through here. I'm not getting that to share for some reason.
Tawny, do you want to unshare your desktop and we can get Tim's hopefully up?
Yes.
That looks better. Can you see that now?
Yep, you're
Great.
good to go.
Very good. So we're going to talk today about two of the laws that passed. The first one that passed in March is called the FFCRA, the Families First Coronavirus Response Act, and then the CARES Act that passed later on. And both of them contain elements that deal with the coronavirus and employees. So first of all, I'm going to summarize the FFCRA. This is not an optional program. This is required for all employers who have fewer than 500 employees, that they provide paid sick leave and extended family and medical leave if any of the specified reasons to COVID-19 are a yes answer. And you have to pay them under the Department of Labor's wage and hour division law, which means that if you are currently paying them below minimum wage for the sick pay benefits and expanded family medical leave, you will have to at least pay them at the higher of their regular wage, the federal minimum wage, or the state minimum wage. And this is for all wages for sick pay and expanded medical leave that are incurred, or that the employee becomes sick and requests time off between April 1st and December 31st of 2020. We'll first talk about the paid sick leave. So employees are entitled to up to 2 weeks or 80 hours of paid sick leave. If it's a part-time employee, it would be their equivalent, their normal equivalent of the 8 hours that would be normally incurred during that 2-week period. And again, like I said earlier, it's at their regular pay rate or the higher of the regular pay rate or the applicable state or federal minimum wage. If they're a part-time employee and they are eligible for leave, and the only thing that they need to do to be eligible is to have been employed for 30 days, then they will receive sick pay for the number of hours that the employee is normally scheduled to work over that period. Now, there are some options here. There's several examples in the FAQ that you can review that if you have extraordinary circumstances, you may be able to find a specific answer to your particular situation. So how much can they receive in that 2-week period? So the employee, if the employee is the one that is sick, they can receive up to 100% of their regular pay, but no more than $511 per day. And they cannot receive over all 2 weeks more than $5,110. And their qualifications are that if the employee is subject to a federal, state, or local quarantine, then they qualify. Or if they have been advised by a healthcare provider that they need to self-quarantine, they qualify. Or if they are experiencing COVID-19 symptoms and they're still seeking and waiting for a medical diagnosis, then they also qualify under that circumstance. Now, if the employee receives 2/3 of their regular pay, up to $200 per day or a $2,000 maximum over the 2-week period, if they are caring for an individual that is subject to a quarantine order, or if, and then the law says if they are experiencing any other substantially similar condition as specified by Health and Human Services. So there's a long list. I went out yesterday and read through what's in that substantially similar condition, and it is pages long. So read through that if you have any questions about whether they qualify. The most typical situation will be that they are at home caring for someone that is either tested positive for the virus, or that they have been tested but you don't have results yet, or are experiencing symptoms. So now we'll switch over and talk about the expanded family and medical leave portion. So there is up to 12 weeks of paid leave, but that 12 weeks also includes the 2 weeks of paid sick leave that we just talked about earlier. But this portion, this additional 10 weeks, is only available if you are required to stay at home to care for a dependent that is home because his school are closed or their place of care is closed due to COVID-19. So the employee receives up to 2/3 of their regular pay, no more than $200 per day, but they can receive up to $12,000 maximum. So if you do the math on this, if you take $200 per day for the 12 weeks, you'll get to that 12,000, or you'll get to a number that will be very similar and will max out at that $12,000. And like I said earlier, the first 10 days for which the employee takes this type of sick leave, again, this is for staying home and taking care of a dependent, then you can require that they use the first 2 weeks of the sick pay benefit rule rather than the Family Medical Leave Act rule. And it's very important here to keep in mind that these are two separate things. So one is when the employee is ill or suspected that they might have the virus, or that they have other qualifying circumstances. And the other one is when they're caring for their dependents and are required to be at home. And again, like I said earlier too, on this one, the only requirement from an employment standpoint is that they have to have been employed 30 days prior to the starting of their benefits. They're not eligible if they have not been employed at least 30 days. So now this is the part where we've been getting the most questions recently, and that is, how do we do all of this? How do we handle all of this? And we've gone through a lot of payroll software packages, and most have adapted their calculations really, really well. The one thing that we've encountered is that for the sick pay benefits, you do not calculate the employer portion of FICA, or the Social Security tax. Some systems cannot distinguish between employee and employer portions. You can either turn FICA calculations on or off, but you can't say turn it on for the employee portion, turn it off for the employer portion. If that's your situation, your only option is to track this manually so that you can make the necessary adjustments on Forms 941 and W-2 at the end of the quarter and or the end of the year. And that's problematic. I would continue to reach out to your software provider and see if they will not update their system to handle this, even if it's after the fact, when you can make adjustments more easily if necessary. So the employer portion of healthcare benefits include the payment for the sick leave or the expanded FMLA, but it also includes healthcare payments, an allocable portion of healthcare payments, the employer portion of those healthcare payments, and you also get a credit for the employer portion of Medicare tax that is matched when you pay an employee. So the tax credit will include those, and we'll go through the actual calculation here in just a minute. So how do I calculate the credit? So the credit under the FFCRA is the total of all sick pay and expanded FMLA payments. You add to that the qualified allocable employer portion of the health care costs, and we'll talk about how you can calculate that in just a second. And then you also add the employer portion of Medicare taxes calculated on the sick pay and expanded FMLA payments. Now remember and keep in mind that no FICA, no FICA or Social Security tax, the employee portion employer portion should be calculated on the sick pay benefits. So you should not be matching the FICA that's withheld from these for the employee for your employer portion. It is exempt from that tax for these purposes. So how do we calculate the allocable employer health care cost? The easiest way that I've found is that most companies can determine what the annual employer contribution to a health care plan is. If you can do that, then this calculation becomes pretty simple. You also may already have it broken down by what your monthly healthcare cost is per employee and what portion of that healthcare cost is paid by the employee. If you can do that, you can also reach the allocable portion fairly easily. And on this next slide, I'll show you an example of how the allocable healthcare cost can be calculated. So in this example, an employee that earns $45,000 a year and their annual employer cost of health insurance is $12,000 per year. And then assume that this same employee receives $1,731 during the pay period in sick pay benefits under the FFCRA. So the calculation to get to the allocable portion of healthcare would be taking your sick pay benefits, divide it by your total annual compensation, and then multiply it by the annual healthcare costs. And that will give you then, in this case, $462 of allocable healthcare costs. If you're doing it on a monthly basis, you could do a similar thing depending upon what your payroll cycle is, whether you're paying twice a month or whether you're paying every 2 weeks. If you're doing it every 2 weeks, it's probably easier to use an annual calculation method. So how do I claim the credit? So the tax credit in the rules says that it's to be claimed on Form 941, which you're all familiar with as the employer's quarterly federal tax return. But the law also allows that in anticipation of receiving the credit, you can receive the funds immediately by reducing your payroll tax deposit. Now, if the credit exceeds the amount of your deposit, the excess can be claimed using a new tax form. It's Form 7200, which is entitled Advance Payment of Employer Credits Due to COVID-19. So here's an example. So as an eligible employer, I have a normal federal deposit due because I just finished payroll and my deposit that's due is $8,000. I also have paid and calculated my credit and it came out to be $5,000. So that's the sick pay benefits, the allocable employer share of health care, and the employer Medicare on those benefits. All those added up. So now what I can do is subtract the $5,000 from the $8,000 deposit that I would normally make, and I'm only required to make a $3,000 tax deposit currently. The IRS is releasing sometime between now and the end of June a new 941 form that will help reconcile all of these adjustments that are being made and for the credits for the sick pay and the expanded FMLA. So watch for that in the future. Here's another example. So same example for the amount of the deposit, but in this case, I've paid $10,000 in sick pay benefits, expanded FMLA, allocable employer health care costs, and Medicare. I didn't include Medicare in that portion of this. And so now my total credit exceeds the amount of my deposit. So in this case, I would not make any deposit for the current payroll period, and I would complete and submit Form 7200, which would give you a $2,000 refund from the federal government for the excess credit. Now, another thing to keep in mind, all of these credits, when you get to the end of the year and you're ready to file your income tax return, are includable in gross income. And so this, even though this is a credit, it's going to be a taxable credit, but keep in mind that all of the expenses for the health care are also deductible. So you're really ending up at zero net when you get to the end, because you do have to pay tax on the credit that's received, but you also get to deduct the expenses that were paid with and through that credit. A couple other items. Any of the sick pay benefits or expanded FMLA payments, if you've received a Paycheck Protection Program loan, they cannot be used for forgiveness on the PPP loans. So you'll have to back those out of your calculation for forgiveness. And qualified leave wages and allocable qualified health care plan expenses are tax deductible. So just keep that in mind as well. You can deduct those on your tax return. Now let's jump over to another portion. This is actually jumping from the FFCRA over to the CARES Act. As part of the CARES Act, there was an option that you could defer the payment of employment tax deposits that are made between when the law was passed in March and December 31, 2020. This applies only to the employer's share of Social Security taxes, or FICA, and self-employed individuals can also defer their quarterly estimated payments for that portion of their payment as well. Now, if you received a PPP loan, a Paycheck Protection Program loan, you may not defer the deposit on any taxes that are due after you've received a decision from the lender that all or a portion of your loan may have been forgiven. Up until that point, you can defer. So this is also in addition to the credits under FFCRA. So you may have received credits for sick pay or expanded FMLA. This is an additional option. It's a deferral of the taxes. The taxes are deferred and not due until later years. So 50% are due on December 31st, 2021, and the other 50% is due by December 31st of 2022. So here's an example. So an employer has a total federal tax deposit due of $17,000, of which $2,800 is the employer portion of FICA. The employer can elect to deposit only $14,200 in this example and defer the $2,800. And if he does that, $1,400 of that deferral, and he doesn't make any other deferrals throughout the remainder of the year, $1,400 would be due by December 31 of 2021, and the remaining $1,400 by December 31 of 2022. A few other things. So Like I said earlier, the IRS is revising Form 941 that will allow for a reconciliation of all of the credits under both the FFCRA and the CARES Act. And we do anticipate that this will be out to the public sometime in June. And just a few resources for you. Go to our website, which is the top line. One of the very best resources I found is the IRS website, and I put a link on here just to the portion that talks about these credits. The other one, there's a frequently asked questions that was put out by the Department of Labor. I put the link to that here. It's a fairly lengthy document, but it does have very good questions, some of which I'm sure will be similar to situations you face in your business. I would also encourage you to read through. There are some good examples on the instructions for Form 7200, and then that last link is just to the form itself. And that's all I have, so I'll turn it back and we'll go to questions if there are any.
Hey, Tim, there are questions. So there's one from Laura, and it says, with many employees opting to stay on unemployment instead of returning to work, how can businesses guarantee that the count is satisfied for the forgiveness?
It's my understanding that if you make an offer for them to come back to work and they turn it down, then you're to report that to the state unemployment office, and they will be at that point be denied their benefits.
Yes, and there's another question about that says, is there anything employers need to provide to workforce agencies to verify that we offered employment back to employee, but they declined? Seems that would make them ineligible for continued unemployment payments. And
That's
Tim,
correct.
I think, yeah, that's like what you said, but I want to kind of add to that. So you do want to report that to the unemployment state workforce agencies. Some states require it, but you as the employer, you will want to report that. One thing you do want to ask though to the employee when, if the worker refuses, ask them why. And if the reason's not one that justifies, so a few of the different reasons that would justify them not wanting to come back and still being eligible for unemployment would be that the worker or a member of the worker's household has been diagnosed with COVID-19, or the worker is unable to reach the place of employment because of a COVID quarantine. So those are a few reasons, but the reason to continue to collecting benefits or a general fear of the virus exposure do not constitute as qualifying reasons, and so they would then be ineligible for unemployment. I know that this situation or scenario comes up because of the CARES Act and that additional $600, the federal supplement, that some people are actually receiving more on unemployment than they would to go back to their jobs. So that could create some issues with people not wanting to go back, but if it's just because they don't want to, then they would not be eligible anymore to receive those. And do your part in asking the reasons why, and then also reporting that to the state workforce agencies. Okay, I have another question here. This kind of has to do with the FMLA expanded. FMLA says, what if it is the daycare provider that is positive for COVID and the employee no longer has care for child? Does the expanded FMLA apply? Place of business wasn't closed as it was an individual nanny.
I would say yes. I mean, if you're unable to obtain the typical child care due to anything dealing with the coronavirus, that's what the law says. That's what's in that last section that I talked about under the Health and Human Services list of other situations. I think that very situation, I remember reading that, where you're just not able to get the child care for whatever reason related to the coronavirus, then you do qualify for the expanded FMLA. Now remember that it's only paid at 2/3 of your regular rate, and it will only pay up to a maximum of $200 per day. And there's the two parts. So if you're claiming that under the sick pay benefits, the maximum there is only $2,000. But if it goes for longer, then the total maximum is $12,000 that you can receive.
Yeah, I would agree with you, Tim. And one thing I just want to clarify for that is the employee qualifies for the leaves if they're unable to work or remotely. Yeah. So if they can work remotely and still care for their children, then they would not qualify for that.
Great, that's a good point, Tawny, and I failed to mention that in my presentation, that it's only if they're unable to work remotely.
Mm-hmm. Okay, so, but what if they are at health risk? Bringing them back will put them at risk. Okay, I think this has to do with my presentation where I mentioned that you need to be cautious when you're selecting who to bring back from furlough because of discrimination cases, and so don't select those who might be higher risk, like for pregnancy or age, because that could be determined as discrimination. And so I think that's where that question stems from. So what my recommendation for you would be, that's when accommodations come in place. So if they do have health risks that they would like to speak with you about, then I would start that conversation and figure out what accommodations can we make for this employee so that they don't have those risks right up front. So whether that be that, you know, they get a closed office, or they, you know, it's the masks and the face masks and all these other things that might help with reducing the risk of putting them back into the workforce. Or maybe it's allowing them to work remotely so that they won't be around other people. But yeah, so hopefully that answers your question there.
And certainly there are some jobs that are much easier, or some are impossible to do in a remote environment. Right. And others are more difficult than some. Maybe a desk job could be done remotely, but some cannot be.
Right, they do have to be reasonable accommodations, and so, yep. Okay, well, I don't see any other questions. Well, maybe there's one more. Is there a time frame required on that reporting to unemployment office? I would just say as soon as you offer the employment back to the employee, and if they refuse it for one of the reasons that doesn't qualify, I would just report it as quickly as possible. I know that at least in Utah, it's when we get unemployment claims, it's a quick turnaround. So I know they're making decisions very quickly, but I would say as soon as you can.
And I believe if you go, at least in Utah, I don't know about the other state unemployment offices, but in the state of Utah, on their website, there is actually a form, and it's right on the front of the website for this very thing. And I believe it's mandatory in Utah that you report if you offered them a position and they've turned it down, except for those qualifying reasons you mentioned.
Mm-hmm. Yes, I believe it is as well. Okay, well, I don't see any other questions. So if there are other additional questions, I'm sure we can have them forwarded to Tim or I, and we can probably just get those answered one by one.
Yeah, I'm very happy to help anybody if they have questions with calculations or special circumstances. Happy to help whoever to get that done.
Yes, thanks for your participation.
Thank you so much, Tawny and Tim. Thank you all for joining us. And I will be sending out an email with a copy of this presentation and their emails in case you need to reach out to them with any other questions. Thanks so much for joining us. All right, guys.